So this is a video post in an embedded blog about a fascinating case that just comes out of Florida's Second District Court of Appeals. The case is called Scott versus Blum, and this has to do with a cyber-stalking injunction in a petition that was filed that had to do with a long-running dispute between two individuals that had some business conflict. Now, an injunction was filed against an individual, and the men who filed the injunction asserted that the statements that were being made about this business dispute rose to the level of cyber stalking. And quite frankly, the Second District Court of Appeals looked at it and found that no, it just wasn't cyber stalking, looked at the clear definition of cyber stalking, compared it with the evidence that was entered, and found that in no way does that evidence support the claim for cyber stalking. Now, importantly, and this is one of the most fascinating things about this case, most of the evidence that was used against the target of the injunction should have been flat out inadmissible for all of the specific hearsay and technical evidentiary bases. But even more important, fascinating here what happens, the target of the injunction tells the judge, be careful with those emails that they're asking you to look at because they've been tampered with. And the judge picks up on that. The judge is looking specifically at the emails, and I've got audio recording of the actual hearing, the entire hearing that's right here embedded within it. And the judge even picks up on this when he says, the evidence has been doctored, tinkered with. You guys have been fooling around with my evidence over and over again. He says, the evidence has been doctored, modified. It's not complete. How do I know all this evidence hasn't been doctored? And so that's really important here because you don't get any of this when you're looking at the written opinion that comes out of the second DCA. You don't understand that the judge himself had very real problems with the evidence that was being used against this gentleman who was the target of a petition for an injunction. Now, it's encouraging, of course, that the second DCA reverses this. They draw some real clear lines about what's appropriate for cyber stalking and what are the other kind of things that are appropriate in a business dispute. But importantly, the appellate opinion doesn't deal with the very sophisticated technical issues that lie at the heart of all this. The fact of the matter is that these issues regarding injunctions and cyber stalking, harassment, First Amendment, all these things are very complex and very technical. The target of this injunction was quite fortunate. He's going to be able to get this injunction released and the case dismissed in all likelihood. But the important thing to recognize is just how technical all of these issues are and how important it is to have advice of proper counsel.